property in 1 year or the profit of a company. When there is no profit in 1 year or a profit of a company is not enough to pay the fixed dividend on preference shares. The arrears of a dividend are to be carried forward and paid before a dividend is paid on the ordinary shares. When there is no profit in 1 year or the profit of a company is not enough to pay the fixed dividend on preference shares. The arrears of a dividend are to be carried forward, paid before a dividend is paid on the ordinary shares. Cumulative preference shares. When there is no profit in 1 year of the there is no profit in 1 year or the profit of company is not enough to pay the fixed dividend on preference shares. The arrears of the dividend are to be carried forward and paid before a dividend is paid on the ordinary shares. Cumulative preference shares. When there is no profit in 1 year or the profit of a company is not enough to pay the fixed dividend carried forward. Industrial dispute means any dispute or difference between employers and employees, workmen and workmen. Industrial dispute means who among the following cannot transport an immovable property? Who among the following cannot transfer an immovable property? इमोवेबल प्रॉपर्टी ट्रांसफर नहीं कर सकते. नेचुरल गार्डियन ऑफ ए माइनर. इमोवेबल प्रॉपर्टी ट्रांसफर कौन नहीं कर सकता? नेचुरल गार्डियन ऑफ ए माइनर. माइनर का नेचुरल गार्डियन नहीं कर सकता. इमोवेबल प्रॉपर्टी. द डॉक्ट्रिन ऑफ लीज पेंडेंस वाज एक्सप्लेन्ड इन द लीडिंग केस Bellamy versus Sabin. Doctrine of lease pendants was explained in the leading case. In which country was the concept of a PL originated? United States of America. PL भगवती जज ने बनाए थे. A question suggesting the answers which person putting it wishes or expects to receive is called. A question suggesting the answers which persons putting it wishes or expect to receive is called. Question. Leading question. A question suggesting the answers which person putting it wishes or expect to receive is called. Leading question. Answer which a person putting it wishes or expects to receive is called. Section 141 of the Evidence Act provides that any question suggesting the answers which the person putting it wishes or expects to receive is called leading question. Section 141 of the Evidence Act provides that any question suggesting the answers person putting it wishes or expects to receive it is leading question. Putting it wishes or expects to receive leading question. A question suggesting the answers the person putting it wishes or expects to receive. Section 141 of Evidence Act provides that any question suggesting the answers the person putting it wishes expects to receive is called leading questions. Option of a pivot is a ground of divorce under the Hindu Marriage Act. Only wife. Ground of divorce. Only wife under Hindu Marriage Act. Which among the following is not the ADR method under the section 89? The CPC 1908 mini trial. ADR method under section 89 of CPC 1908. Section 89 of CPC empowers the civil courts to refer matters to the alternate dispute resolution methods, judicial settlement including लोक अदालत. देश को बचाने के लिए कॉमन पर्सन और फार्मर को चुनाव लड़ना चाहिए. कैन पॉलिटिकल पार्टी डिक्टेटर इन एवरी कंट्रीज. पीस शांति के लिए सबको चुनाव लड़ना चाहिए. एंड डोंट वोट टू डिक्टेटर्स पॉलिटिकल पार्टी. इंडिपेंडेंटली कंटेस्ट इलेक्शंस. The maximum number of conciliators allowed in a conciliating proceeding re none of 6496. Conciliator explanation. Section 64 of the Arbitration and Conciliation Act 1996 deals with the appointment of conciliators. It provides that when the invitation to a conciliation is accepted by the other party, the parties have to agree on the composition of a conciliation tribunal. In the absence of any agreement to the contrary, there shall be only one conciliator. Thus, the conciliation proceeding may be conducted by a sole conciliator to be appointed with the consent of both the parties, failing to which the same may be conducted by two conciliators. Maximum limits 3. Limit 3. Then each party appoints one conciliator. And the third conciliator is appointed unanimously by the both parties. Third conciliator. So appointed shall be the presiding conciliator. In addition to the conciliator is in the other party, in person of the Constitutional Tribunal. Consent of both the parties, failing to which the same may be conducted by two conciliators. What is status of a settlement agreement in conciliation proceeding? What is status of a settlement agreement? Same as a settlement award. Status of settlement agreement in conciliation proceeding. Section 73 of the Arbitration and Conciliation Act. This is settlement agreement. In conciliation proceeding, status of settlement agreement. Section 73 of Arbitration and Conciliation Act 1996 deals with settlement agreement. Under Section 118 of the Indian Evidence Act, a person is a competent witness of if he or she What is status of settlement agreement in a conciliation? 73 of the Arbitration and Conciliation Act 1996 deals with settlement agreement. Settlement is capable of understanding question put to him and giving rational answers irrespective of age. Section 108 of Indian Evidence Act 1872 provides that all persons shall be competent to testify unless the court considers that they are prevented from understanding the question put to them or from giving rational answers to these questions. A tender years, extreme old age, disease, whether a body or mind, or any other cause of same kind. Section 118 of the Indian to human giving rational answers irrespective of age. Indian Evidence Act, a person is a competent witness if he see understanding question put to him, giving rational answers. Section 118 of the Indian Evidence Act 1872 provides that all persons shall be competent to testify unless the court considers that they are prevented from understanding the question, giving rational answers to this question by tender years. body or mind, but any other cause of the same kind. Sections 108 of the Indian Evidence Act. All persons shall be competent to testify unless the court considers which of the following judgment is irrelevant under Section 43 of Indian Evidence Act. Judgment of a criminal court. Section 42 judgment of a criminal court. Indian Evidence Act. Section 40. Section 42, Section 44 of Indian Evidence Act 1872 lays down provision relating to judgment of Court of Justice. Relevant. Section 40 deals with the Evidence Act. Criminal Court का Indian Evidence Act. Judgment of Court of Justice then relevant. Section 40 deals with the provision judgment to bar a suit of a trial. Section 41 deals with the relevance of certain judgment. Under which section of the Indian Evidence Act a witness has been given right to repress his memory? Section 159. This section Indian Evidence Act a witness has been given right to repress memory को repress करने के लिए. Under section 159 of Indian Evidence Act, witness has been given right to repress his memory. Any writing made by himself at time of a transaction concerning which soon afterward the court considered likely the transaction was repressed. Professional treatise, you see, witness in expert. Any such writing made by any other person and read by witness within the time aforesaid. Mandamus may be issued by both AIBE. The writ of mandamus may be issued by both Supreme Court under Article 32 of Constitution and High Court under Article 3. Under which section of the India Evidence Act witness has been given right to repress his memory during the examination by referring to the following documents made by himself at time for transaction concerning he considers soon memory. Any such writing made by any other persons within the time aforesaid. Professional treatise, if he